A very good evening and a warm welcome to another episode of Law and Order. And today we are going to discuss on a very special and interesting area of law which matters to the developing world in an enormous way. And that is none other than condominium property law, or apartments as we know it. So generally, the traditional way of building houses was that people used to buy lands and build houses on them. But now, with the rise in urbanization, we see that more and more people are moving towards purchasing condominium parcels or condominium property in urban areas throughout the island. And there are certain aspects of law which are specially applicable to these condominium property, and it is vital that we get an understanding, a broad understanding into these elements of law. And for this special discussion on apartment ownership law, we are more than happy to welcome to Sri Lanka Rupavahini Channel Live Studio Ms. Ajitha Idirimana, attorney at law. She is a graduate from the University of Colombo and thereafter completed her master's in law and business from Germany. A very good evening, madam.
Thank you for inviting me. Good evening, Shahada.
So my first question is, now, of course, we are used to the traditional way of purchasing land, where, by a deed of transfer or a deed of gift, one would get land, in the sense land on the ground. But now people are moving towards getting full ownership of apartments, apartment units. Sometimes they purchase apartment units of property which has not even been built. So this is a new concept to certain people. So my first question, very bluntly, what is this? What is an apartment and what is the law governing it?
Okay. Now, in our country, for immovable property, the law that is applicable, as you know, is Roman Dutch law. Now, if we take only Roman Dutch law, it will be very difficult to give title to a unit in a subdivided building, because as you know, in Roman Dutch law, anything built on a block of land belongs to the owner of the land. So we had to move away from Roman Dutch law to create this new regime for separate units of a subdivided building. How we did that was by enacting a statute. The first apartment statute was enacted in 1973. It's called Apartment Ownership Law number 11 of 1973. Subsequently, this was amended in 1945, and the last amendment was done in 2003, Act number 39 of 2003. So, if a developer registers a subdivided building in accordance with the provisions of this apartment ownership law, title can be given to a unit on a horizontal layer of a building. So that's how we move away from Roman Dutch law and come into this concept of apartment ownership law.
And also now we see that a lot of people are moving towards buying condominium property, and also many individuals rather than companies are moving towards building apartments, because now building an apartment has become lucrative business, especially with the competition for land and the rise in urbanization. People are moving towards Colombo or different town areas of different provinces. So there is very less space in those town areas. Hence, there is a major demand for condominium property. As a result, individuals also tend to move into developing condominium property. Now, my question is it always businesses who or companies which go into condominium development, or does individuals also go into it? And is it difficult to be a condominium developer?
Okay. Now, developing a condominium property might look easy if for a person who owns a block of land. Basically, now let's say if he has 20 purchases, that's how people think, okay, I can make a lot of money by creating units on a multi-story building constructed on my block of land, rather than selling this outright. But it is not so easy as one would perceive, because to become a developer, owning a block of land alone is not enough. You need to have sufficient funding, because multi-story property development means you need a lot of financial backing, you have to employ labor, resources, so on and so forth. Not only that, you have to get a series of approvals, clearances. So it's not easy for an individual owner. So what people normally do who have large blocks of land, is that they would prefer outright selling it to a developer, a corporate entity or a professional person. And that developer would thereafter get all the necessary approvals to start a condominium project. But I must at this point tell you, in our country there is no mandatory requirement to get a license for a condominium property development. Anybody, if he or she feels okay, I'm going to do this on my own, can do it, because there is no mandatory requirement. But in Singapore, a person who wants to embark on a condominium property project has to have a license if it's more than 3 floors, more than 10 units, and also there must be proper financial backing, in the sense if it's a corporate entity, they have said so much of Singapore dollars has to be invested in that corporate entity. But we don't have anything like that. But now when we look at this from the aspect of a prospective buyer, it is a risk. I mean, you don't know where you are venturing into, whether this developer will be able to complete the project if he doesn't have the requisite knowledge. So what I would advise at this moment is that prospective purchasers must check whether the developer has done similar projects in the past, what kind of experience he has, and has he been successful in these projects. And also the contractor that has been engaged for the project, has that contractor been registered at CIDA? CIDA is Construction Industrial Development Authority. So we can expand on that later.
And also, you mentioned that there are a series of approvals which are necessary for condominium development. Would you like to elaborate on what kind of approvals are necessary and what's the law behind it? So if a viewer who is watching our program today wishes to embark on developing a condominium property in his land, what are the legal aspects he should consider?
Yeah, primarily a developer must get a development permit to start a condominium project. Now there are lots of developers who offer units of a multi-story building which has not even been registered as a provisional condominium property. Then when you check the background, you find that this project doesn't even have a approved development plan and consequently a development permit. That's really a very essential point that any prospective purchaser should look into. So when we talk about from the side of the developer, a developer should necessarily hold an approved development plan. Okay, that is, the building plan should have been approved for a condominium project and should have a development permit. But what I see generally in our country is that developers just only get the preliminary clearance for the project. That preliminary clearance is just a kind of investigative document. The authority would say these clearances should be obtained, like sewage clearance, water line, so on and so forth. But it does not say that this particular project has been granted approval. So if a person wants to engage in condominium property development, he or she must do it in the proper way. That's what I would advise, and should not start offering sales agreements without having the requisite development permit.
And also, now you mentioned that there is a possibility of completing a condominium building and then selling off units. And there is also a possibility of selling off units before completing the building as well. Could you explain on the law behind it as well?
Now, in the amendment to the apartment ownership law in 2003, a possibility was created to pre-sell units. That is, you sell units which are depicted in a condominium plan, but it's not actually not completed. You don't see the physical actual completion. So there are 3 types of condominium projects which have been addressed in this apartment ownership law amendment of 2003. For the very first time, provisional condominium property was given recognition. That is, the developer would register the provisional condominium plan of the proposed building, And then when you register this provisional condominium plan with a deed of declaration, what would come into existence would be these provisional units, that what you see only on paper. But because that is given recognition in law, you do have a subject matter. And when you submit the deed of declaration with the provisional condominium plan to the relevant land registry or a title registry, provisional units are created, and in the case of registration of documents ordinance, separate folios are opened up for these provisional units. So, and the law is very clear that these provisional units can only be used for pre-sales, but not for deeds of transfer. So, that is provisional condominium registration. Now, when a developer completes the entire project and registers the completed condominium plan with a deed of declaration, then directly what comes into existence would be these completed units registered in different types of folios, that is for completed units, and subsequent to that deeds of transfer can be done for transfer of title.
And also, while the developer takes those approvals and condominium, on pre-arranged sales agreements about condominium property, is the developer required to take any, let's say, is there any process of registration or is there any supervision done from the government's perspective?
Yeah, that's a very good question. Actually, there is no such supervision right now, because as I told you, I have seen many developers just starting projects without even the approved development plan, because this process takes a long time to apply. Now, if a project comes within an urban area, then as of 2017, the developer has to seek approval from the UDA, Urban Development Authority, or the local authority in that particular area. So, to submit an application, now as I told you, first of all they will submit the application for preliminary planning clearance. So, in that document they would say these, based on the location of the project, they would say these clearances have to be obtained. So, it is not easy, it takes a long time. So, what the developers are in a hurry to complete, they want to raise funds, they want to move ahead with the project. So, they would just start with the preliminary clearance, which is not even approval. But now when you do have your development permit, it means basically what you are doing is the correct thing, because all the approvals have been granted. So, that's how it would be.
And also, now we spoke about the developer's perspective. Now, there are also many people who are willing to purchase condominium property, and sometimes they might enter into a pre-sale, that is prior to completion, they might enter into a sale, or they might purchase a condominium property which has been created. So, if a viewer here is willing to or is planning on purchasing condominium property, what advice would you give? What should he or she be cautious about? What precautions should he take? And also, what is the law behind all of such precautions?
Yeah. Now, a person who wants to purchase a unit which has been advertised in the marketing brochure would necessarily check whether this developer or the owner of the land has proper title. That's the first requirement. Now, person would not be able to do this on his own, so they would have to get legal advice. So, when a person does a title search at the land registry or the requisite title registry, you might be able to find out whether there are any encumbrances attached to the land, whether there are any mortgages, caveats, and so on and so forth. Then, even if the project is in a good location, my advice is you should be cautious in putting down your hard-earned money, because if the developer does not have proper title, or if the title has certain encumbrances, that means unless those encumbrances can be taken off, like by way of a deed of release in the case of mortgages, then putting down your money for this unit in such a project is a risky venture. But at the same time, I must say developers has to raise loans, and it is sometimes unavoidable that you have to mortgage the land. But that is for funding required for the project. But now prospective purchaser must firstly check whether the title is there, then whether there are any encumbrances. If there are encumbrances, check with the developer at which stage these encumbrances can be removed, that is by way of deeds of release. Then also whether there is clearances from the authority, that is street line clearance, then ownership certificate, then also, as I said earlier, very important, does the developer has a development permit? That's absolutely important. Now people might give sales agreement and say, this is you have to sign this, I'm very sorry, we can't make any changes to the clauses. But then if you're putting down a lot of money, you need to ask these questions. Thereafter, if now lawyers advising clients would also must bring this to the notice of the clients. But if the client feels, okay, I don't mind, I feel it's all right for me, I will put down my money for this project, then it's up to the client or the prospective purchaser, because he is willing to take the risk. So apart from that, once the project is completed, there should be a certificate of conformity. The COC is issued by the relevant authority, which confirms that the building has been completed in accordance with the approved building plan. So COC is absolutely necessary. And then of course, if you need to check whether once it's completed, now we are talking about the completed site, whether the building has been registered as a condominium property. But if you are talking about a building which is yet to come up, then my advice is ask about the development permit. If it's not yet been given to the developer, then also one can insist, please, I'd like to have a clause in the agreement that till this development permit is obtained, I am not required to put any further money. Maybe I'll give so much as a reservation fee, but I do not want to commit myself till the development permit is obtained. So there are so many matters which a prospective purchaser should look into before putting down their money.
And also now usually purchasing a normal land would only require a deed of transfer. Can a condominium property be transferred in the same way as a deed of transfer?
Yeah, as I told you, now when we created this new regime called condominium properties, we moved away from Roman Dutch law and came within the ambit of apartment ownership law, which gave title to a registered subdivided building if it has been registered in accordance with the provisions of the apartment ownership law. So when it is completed, thus registered, the unit would have freehold title, which means if there's freehold title, you can transfer the unit just like in any other way by means of a deed of transfer.
And a simple deed of transfer.
A simple deed of transfer, but in this case, in the deed of transfer, in the schedule, you would describe the 6 different boundaries of a unit, also the share value that's assigned to the unit, and the common elements of the unit.
And that is, I think, a very remarkable, a noteworthy point, because usually in a deed of transfer it would only be 4 boundaries. Yeah. But with the new regime, which under a condominium property, in addition to the 4 boundaries, you have 2 other boundaries, which is the upper boundary and the lower boundary.
Yeah, Zenith and Nadir.
Yes. And also along with that, my next question comes to, you spoke about common elements. And what do you mean by common elements, and to whom does it really belong to, and who should maintain common elements?
Okay, now common elements in a condominium property are all those areas which do not get caught to a unit. So like now if it's a residential condominium property, the units would be all those which are habitable, where people can live. So if you take out all those units, the rest of the area like the corridors, the lifts, the parking, swimming pool, gardens, all that would be common elements. Now in a condominium property, there are 2 types of ownership. That is the ownership the freehold title of the unit, and the undivided ownership of the common elements. So, as regards the common elements, the unit owner is a co-owner. So, he is total owner of the freehold unit and a co-owner of the common elements. Now, the amount of co-ownership that is attached to the unit is depicted in the share value given for the unit. Share value is indicates the undivided ownership of the common elements assigned to that particular unit. Now, these common elements are so vast, so therefore administering and managing the common elements is not an easy task. Now, when a deed of declaration with the condominium plan is registered at the land registry, automatically a corporate entity called a management corporation comes into existence. Now, the purpose, the objective of this management corporation is to administer and maintain the common elements. And the members of in any corporate entity, there are members. In this particular case, the members are all those unit owners of the condominium property. Automatically, they when they get the deed of transfer, they become a member of the management corporation. The management corporation on its own cannot maintain and manage this vast area. So, the Act has enabled council to be appointed, just like a board of directors in a company. So, and this first council is appointed by the condominium management authority, which is the supervisory body, statutory supervisory body of condominium properties.
And in that case, the common elements or the common areas, the stairways, corridors will belong to all the owners of all the condominiums.
Yeah. They are co-owners, and the ownership is based on the share value assigned to the unit.
According to the share value.
Yeah, you can't sell the common elements separate from the unit. All are together. When you do a deed of transfer, that's why I said you have in a third schedule the common elements. Everything is passed on to the other party.
And also the maintenance of the common elements is usually done by the condominium management corporation. And does this corporation have the right to charge a fee from the owners of condominium parcels?
Yeah, that's a very good question, because now this management corporation is entrusted with a vast amount of work. Administering, maintaining, managing.
Security.
Means, yeah, so much of work. So how can they do this if they don't have the money? So the money that is used for this is obtained from each unit owner by levying a fee called a service charge or a management fee, and it is credited to a management fund.
All right, madam. And with that, we would end today's episode on law and order. And today's discussion was on the law governing condominium parcels, or the law governing apartments, something which is vastly developing all over Sri Lanka, something which a lot of business ventures are going into, and something where an area of law where a lot of individuals are personally investing and also personally purchasing condominium parcels. So with that insightful and useful discussion, we would like to end today's Law and Order program, and we would like to extend our sincere thanks to you, madam, for gracing this occasion and for sharing your wealth of knowledge with us. It was a great honor to have you here.
Thank you for inviting me. Thanks.
Thank you, and we wish you a pleasant night.